Case 64, Jifry versus FAA. We find ourselves in the U.S. Court of Appeals for the D.C. Circuit. Facts. Petitions filed by two non-resident alien pilots challenge certain aviation regulations adopted in the wake of September 11, 2001 terrorist attacks. From the establishment of the TSA in November 2001 to the promulgation of the challenged regulations in January 2003, aviation security has undergone a fundamental transformation. The pilots contend that the new procedures resulting in the revocation of their airman certificates issued by the FAA violated the APA and the Due Process Clause of the Fifth Amendment of the U.S. Constitution. Specifically, they contend that the January 2003 regulations were unlawfully promulgated without notice and comment, that the revocations were not supported by substantial evidence in the record, and that they were denied meaningful notice of the evidence against them and a meaningful opportunity to be heard. The two pilots, Jifry and Zari, are citizens of Saudi Arabia who have used their FAA certificates to pilot flights abroad, but have not operated Saudi Arabian airline flights to the US in the past 9 and 4 years, respectively. On August 14, 2002, the TSA sent letters to the FAA requesting that Captain Jifry and Captain Zari have their airman certificates revoked, stating that based upon information available to us, they presented a security risk to civil aviation or national security. The FAA notified Jifry and Zari by letters on August 20, 2002, that their airman certificates would be revoked because the Acting Undersecretary of Transportation for Security had determined that they presented risks to aviation or national security. The FAA revoked the pilots' certificates, and the pilots appealed the revocations to the NTSB. An ALJ had a telephonic pre-hearing conference on January 17, 2003 and ordered that the FAA and TSA provide a privilege log and that depositions of key witnesses take place by mid-February. A week later, on January 24, 2003, the FAA dismissed the revocation actions against Jifry and Zari, and in conjunction with the TSA, published without notice and comment new regulations governing the suspension and revocation of airman certificates for security reasons. The new FAA regulation, 14 CFR 6118, provides for automatic suspension by the FAA of airman certificates upon written notification from the TSA that the pilot poses a security threat and therefore is not eligible to hold an airman certificate. The TSA simultaneously promulgated 49 CFR 1540.117, which establishes the procedure by which the TSA initially and finally notifies non-resident aliens who hold or apply for FAA certificates that they pose a security threat, and requires the TSA to notify the FAA once the TSA has determined that a pilot is a security threat. Upon finding that a pilot poses a security threat, the TSA Assistant Administrator for Intelligence issues an initial notification of threat assessment to the individual and serves that determination upon the FAA. The FAA then suspends the pilot's certificate. On January 24, 2003, the TSA also served an initial notice of threat assessment designating Jifry and Zari as security threats, and the FAA suspended their certificates. The pilots appealed the initial notice and requested the materials upon which the initial notice had been issued. On August 13, 2003, the NTSB denied the pilots' appeal of the revocation of their certificates for the same reasons it had denied their challenges to the suspensions, and affirmed the ALJ's grant of summary judgment to the TSA and the emergency orders of revocation. So what's the issue? Whether the January 2003 regulations were unlawfully promulgated without notice and comment, whether the revocations were supported by substantial evidence in the record, whether the procedures provided by the January 2003 regulations violated their due process rights under the Fifth Amendment of the Constitution. Holding. The court affirmed the NTSB revocation order of August 13, 2003, and denied the petitions for review and the pilot's motion to bar the respondent's reliance on classified information. Reasoning. Congress has delegated broad discretion to the FAA to prescribe regulations and standards for safety in air commerce and national security. The FAA may at any time re-examine the issuance of an airman certificate and issue an order modifying, suspending, or revoking a certificate if the administrator determines that such action is required for safety in air commerce and the public interest. After the September 11, 2001 terrorist attacks, Congress established the TSA on November 19, 2001, and transferred much of the responsibility for civil aviation security from the FAA to the TSA. On the first issue, the court began with Section 553 of the APA that requires an agency to publish a general notice of proposed rulemaking and to afford an opportunity for interested persons to participate in the rulemaking. The good cause exception, however, provides that when the agency, for good cause, finds that notice and public procedure thereon are impracticable, unnecessary, or contrary to the public interest, the agency need not engage in notice and comment. The pilots contended that the regulations of January 2003 were invalid because they were unlawfully promulgated without notice and comment, and there was no rational basis for eliminating the right to a meaningful appeal before the NTSB. The good cause exception did not apply because the FAA already had the authority to immediately suspend or revoke a certificate upon finding that safety in air commerce or air transportation and the public interest required such an action. The pilot's APA challenge failed. The court's review of agency rulemaking is highly deferential, limited to determining whether the agency has considered the relevant factors and articulated a rational connection between the facts found and the choice made. Contrary to the pilot's position, the regulations were not arbitrary and capricious, forbearing no rational connection to the problem identified by the FAA, according to the court. The court reasoned that it is self-evident that the regulations are related to the TSA's and FAA's goals of improving the safety of air travel. Nor was the court in a position to second-guess the respondent's judgment that imposing stricter procedures for coordinating security risks and restricting individuals who pose security threats from holding airman certificates was necessary to further that goal. On the second issue, the pilots contended that the revocations of their airman certificates were unsupported by substantial evidence in the record, but the pilots failed to challenge the definition of security threats under the TSA regulations. Pursuant to 49 CFR 1540, an individual poses a security threat if the individual is suspected of posing or is known to pose a threat to transportation or national security, a threat to air piracy or terrorism, a threat to airline or passenger security, or a threat to civil aviation security. Consistent with Supreme Court precedent, when an agency official fails to adequately explain its decision, the agency should submit, either through affidavits or testimony, such additional explanation of the reasons for the agency decision as may prove necessary. Here, the affidavit of TSA Deputy Administrator provided an adequate basis for the TSA's determination that Jifry and Zari each posed a security threat within the meaning of the law. The unsealed affidavit recounts that the Deputy Administrator affirmed the TSA's determination on the basis of classified intelligence reports, combined with reports from the intelligence community, that aircraft would continue to be used as weapons of terrorism, and consideration of the ease with which an individual may obtain access to aircraft in the U.S. once he or she has a pilot license. The Deputy Administrator attested that because it would be very difficult to avert harm once a terrorist had control of an aircraft, I concluded that it was important to err on the side of caution in determining whether the two pilots pose a security threat. Viewing the record evidence before the TSA, including ex parte in-camera review of the classified intelligence reports, the court held that there was substantial evidence to support the TSA's determination that the pilots were security risks. While we reject the pilot's contention that the court apply a de novo standard of review, we have carefully reviewed the classified intelligence reports on which TSA relied. The record is not lengthy, and the basis for the TSA's conclusion is obvious. Finally, the court reviewed de novo the pilot's challenge to the constitutionality of the procedures under the January 2003 regulations. They contended that the TSA and FAA procedures violated the Fifth Amendment of the Constitution by depriving the pilots of their property interest in their airman certificates without due process of law. The Supreme Court has long held that non-resident aliens who have insufficient contacts with the U.S. are not entitled to Fifth Amendment protections. Exceptions may arise where aliens have come within the territory of the U.S. and established substantial connections with this country or accepted some societal obligations. In this context, the Jifry court opined that it did not need to decide whether Jifry and Zari are entitled to constitutional protections because, even assuming that they are, they have received all the process that they are due under our precedent. The pilots' interests at stake here, their interest in possessing FAA airman certificates to fly foreign aircraft outside of the US, pales in significance to the government's security interests in preventing pilots from using civil aircraft as instruments of terror. As the Supreme Court has noted, it is obvious and unarguable that no governmental interest is more compelling than the security of the nation. Whatever the risk of erroneous deprivation, the pilots had the opportunity to file a written reply to the TSA's initial determination and were afforded independent de novo review of the entire administrative record by the Deputy Administrator of the TSA and ex parte in camera judicial review of the record. In light of the governmental interests at stake and the sensitive security information, substitute procedural safeguards may be impracticable and, in any event, are unnecessary under the court's precedent.